You're watching the legal breakdown. So, Glenn, we've actually got some big news from the Supreme Court. We've been holding our breath that the Supreme Court wouldn't drag its feet on the question of Trump's presidential immunity claims in his Washington, D.C. trial. Nothing can move forward until the Supreme Court makes that decision, including this trial. But we've got some surprise movement here. Can you explain what happened?
Yeah, this is something of a surprise. So first of all, Jack Smith filed a petition to have the Supreme Court take the case basically instantly. What does that mean? It means that the case would leapfrog over the DC Federal Circuit Court of Appeals, which is unusual but not unprecedented. And the Supreme Court would take up the question pronto. Here's the thing. Jack Smith has filed the motion seeking that expedited review, but the Supreme Court thus far has said, okay, we're willing to hear you out, and they ordered the Trump team to file a reply to Jack Smith's request very quickly, December 20th. So we don't quite know how it's going to play out yet, but what I think we can tease out of this, Brian, is the Supreme Court seems to understand the urgency of the moment, and it looks like they may even meet the urgency of the moment.
Now, does the fact that the Supreme Court is expediting consideration of that petition by Jack Smith mean that they're definitely taking up this issue?
It doesn't, but I do think it's a pretty good indicator. I think they're tipping their hand a little bit. Look, if they just wanted this case to run its ordinary course, just, on a leisurely pace through the lower appellate court up to the Supreme Court, maybe not. If they wanted to put this case on a slow train to a possible dictatorship, giving Donald Trump the opportunity to perhaps, make his way to and through the 2024 presidential election without any of his prosecutions yet having been, played out in court. They could have done it. Feels like they're not interested in that.
Now, if they're expediting consideration of this request by Jack Smith, does that mean we can expect an expedited ruling on this issue as well if they do take it up? Or does one have nothing to do with the other? Does them accepting this petition by Jack Smith not have any bearing on how quickly they would rule?
Great question. I think legally speaking, there is not necessarily a connection between their decision to sort of hear this issue very quickly. In other words, whether they should assume responsibility for the case immediately or not. I don't think there's any legal relationship between that and any guarantee that they will decide it quickly. But even more importantly, I think there's a practical relationship. It is already out of the normal course for a prosecutor to file a request like this. Again, not unprecedented. And this has happened before. There was a prior case where the Trump administration wanted to put a citizenship question on the census. That is one that leapfrogged over the intermediate appellate court, went right to the Supreme Court so they could decide it quickly. So I think practically speaking, the fact that we have seen Jack Smith file the request and the Supreme Court accept that filing and direct the Trump team to basically respond to it at light speed, I think is the best indication that they're probably going to accept review of the case. And even more importantly, if they do, because they seem to be acting based on the urgency of the moment, they will probably decide the issue quickly so that the March trial date can remain in effect.
Okay. Glenn, what's at stake here? What happens if the Supreme Court rules that Trump is covered by presidential immunity?
Yeah, I guess it's only our democracy at stake, just small potatoes, right? Here's the thing. I mean, people need to realize there is zero legal support for Donald Trump and his lawyers' claim that a president is absolutely immune against prosecution. Think about that. A president, while in office, could commit any and all crimes with impunity, would never have to worry about being held accountable for it, being prosecuted for it. Literally, to put it indelicately, a president could order his political opponents assassinated. So there's no legal support for it. When I say no legal support, there are three kinds of law that can make an appearance on a question like this. One is a federal statute, a law passed by Congress, signed by the president, saying we are granting presidents absolute immunity from prosecution. There could be a law passed it might be challenged, but there could certainly be a law, a statute. Two, there could be what we call case law, precedent from an appellate court that had to decide this issue previously. And once an appellate court decides an issue, it becomes what we call case law, precedent that other lower courts under the jurisdiction of that appellate court must follow. And then the third source of law is the Constitution. There is no statute, there is no case law, and there is no constitutional provision that provides a president is immune from prosecution. So, when Donald Trump makes this assertion and when his lawyers put in writing that, the law supports that a president is absolutely immune from prosecution, they're basically making it up out of whole cloth. They're hopeful because that may be the only shot Donald Trump has at avoiding criminal responsibility for what he's done. But let's apply common sense to that for just 1 minute. If Donald Trump and his lawyers, as they have put in writing in court filings, truly believed he was absolutely immune from prosecution, he would want the Supreme Court to take up that issue yesterday.
Right.
Why? Because then the Supreme Court would say, you're right, Donald, you are absolutely immune. You can't be prosecuted. And that means this case that Jack Smith has brought has to be dismissed right now, and you're free to head off to the campaign trail. So don't you think Donald Trump and his lawyers would join Jack Smith's request to get this thing to the Supreme Court pronto so they could rule in his favor? That shows the weakness, indeed, the frivolity, the laughability of Donald Trump's claim that a president is absolutely immune.
Now, Glenn, just to play devil's advocate here, with all of that said, even though there isn't any precedent, no case law, and no statute, nothing in the Constitution, there is still the possibility that Trump's allies, political allies, partisan allies on the Supreme Court could still rule in his favor, isn't there?
Absolutely. If the Supreme Court justices want to abandon their responsibility, their honor, their ethics to interpret the Constitution in a way, that can literally be found in the text of the Constitution, then they can do whatever they want. They can act in a completely lawless manner and do a favor, though, for an aspiring dictator like Donald Trump. Here's why they won't do it. I'll bet the full buck on this, Brian. They won't do it because what they will be doing is they'll be delivering the power of the judiciary to a criminal president. They will literally be putting a criminal president above and beyond the reach of the law and the Supreme Court. The Supreme Court loves its supreme status. The last thing they're going to do is hand it over to a criminal president and make themselves, the judiciary, a second-class branch of government. It's not going to happen. But you know what, Brian? If it did, and you and I were talking about this the other day, if they decided that a president was absolutely immune from prosecution, well, then Joe Biden could simply follow Donald Trump's January 6th blueprint. He could commit crimes to retain power, to stay in power, and he couldn't be prosecuted for those crimes. And frankly, he could have learned a little something from the way Donald Trump tried to execute his criminal plan to retain power. It failed, but Joe Biden could learn the lessons of that failure, could do it successfully, could remain in power, committing crimes to accomplish that, and could not be prosecuted. Now, Joe Biden wouldn't do that, but that's another reason the Supreme Court will not endorse a president as a king who is above the law.
Right. And Joe Biden could presumably just invoke the Supreme Court's decision every step of the way. But again, to your point, he wouldn't do that. But this ruling granting Donald Trump presidential immunity would give Joe Biden license to do that if he wanted to. Glenn, could the Supreme Court simply do nothing and just agree with the district court judge, Judge Chutkan, who has already ruled that Trump isn't covered by presidential immunity while doing things that aren't considered official duties, like, say, inciting an insurrection?
I don't know that they could do both of those things. In other words, they could do nothing, but nothing would look like letting this case run the ordinary course, which means the D.C. Federal Circuit Court of Appeals would be next up.
Got it. And then eventually it would go right from that appeals court right back up to the Supreme Court when it inevitably gets appealed by one side or the other, and then they would have the same problem on their lap that they have right now.
We're in the exact same place. So why not cut to the chase, right? Cut out the middleman, let the Supreme Court decide it. Now, the other way they could do nothing is they could say, we agree with the trial court, Judge Chutkin's ruling, opinion to follow. What that would do is instantly resolve the issue.
Got it.
The March 4 trial would remain on track, and then we would just have to await the legal opinion from the Supreme Court. I think that a little bit less likely.
What is the likely timeline here? What can we expect in terms of next steps in this case immediately? And when can we expect a final resolution? I know the second part of that is a little bit of a guessing game.
Yeah, I think the next step is we will learn what position Donald Trump takes and his lawyers take on December 20 when they file their brief. And then I have a feeling, Brian, I mean, it really is pretty ground shaking that the day Jack Smith filed for this extraordinary process, the Supreme Court that very day ordered Donald Trump's lawyers to respond by December 20th. That is a sure sign that they're going to move quickly. And I think they will move quickly because I really do think they are sensing the urgency of the moment with the upcoming election. So, I have a feeling this could be resolved certainly in a way that kept the March trial date intact. They did expedite a similar situation back in 1974 with the Richard Nixon subpoena. Now, that was a slightly different question. That question didn't have to do with whether a president is immune from prosecution, but it had to do with a related issue. Is a president immune from having to comply with a subpoena in a criminal case, a subpoena that was seeking information, evidence in a potential criminal case? And the Supreme Court unanimously said, of course, the president is subject to that. It's really not that much of a legal leap from the Nixon ruling 9-0, unanimous by the Supreme Court in 1974, and extending it to, just like we said in 74, that he was subject to the criminal process and procedures when it comes to a subpoena. He can also be prosecuted for his crimes. And I think that's what we're ultimately going to get out of the Supreme Court.
Well, let's see if Clarence Thomas agrees here. Just a quick question, Glenn, that interested me in terms of what you had just said. When the Supreme Court decides to take this issue up, who specifically is making that decision? Is it Chief Justice John Roberts? Because there are certain members of the court who I would presume wouldn't want to move on this expeditiously because they would want to grant Trump the delay that he's seeking. So when you say that on that same day that Jack Smith made this petition or sent this petition over to the Supreme Court, they accepted it, who was it that made that decision?
What a great question, Brian. I think ordinarily, my understanding is it takes 4 justices to grant review of a case. That, of course, is different from what we just saw. We saw, I think, a 1 or 2 sentence order that didn't say anything about who or how many justices supported it, but it just said, we want a reply from Team Trump by December 20. I don't know. And I'm hesitating to even speculate because I don't want to be wrong. I don't know what the process was that was involved in the Supreme Court reaching that conclusion. We want a reply. They certainly could have just sat on or ignored Jack Smith's motion. They could have taken as long as they wanted to decide whether they were going to even, dip a Supreme Court toe into this water. So I'm going to decline to answer that question because I don't know, and I really don't want to engage in speculation that might be dead wrong.
Yeah, and by the way, to your point, there may be no process for something like this because we're kind of in unprecedented waters with regard to all of this right now. But obviously a lot to look forward to, especially as we keep an eye on that December 20th date to see what the Supreme Court says in response to Donald Trump's team's response to the petition that was sent in by Jack Smith. So for anybody watching, if you want to stay on top of this case, as soon as we have any developments, please make sure to subscribe. The links are right here on the screen. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.